In this video, let us try to understand how the court will characterize a case that is having the presence of a foreign element in it. Before going into this video, if you have not watched the basics of characterization, kindly click on the link given below in the description. It will help you to get a better understanding of this particular case. The facts of this case are somewhat like this. This is a case that was filed in USA, a divorce case filed in USA. Now the couple, Ahmed Farah and Naima Manzoor, had got married in England through proxy marriage. Ahmed Farah belonged to Algeria, Naima Manzoor to Pakistan. After the proxy marriage took place, they had their matrimonial residence in Virginia for many years. Ahmed and Naima belonged to Ahmadiyya sect, and the Nikah the proxy marriage that took place during that time period, the Nikah stipulated a deferred dower payment of $20,000, which meant that in case of divorce, 20,000 rupees needs to be paid by Ahmed Farah in favor of Naima Mansoor. The proxy marriage actually took place in London. Neither Ahmed nor Naima were present. Through their agents, the marriage was concluded. After the marriage took place in London, the parties decided to settle in USA. The point that we need to remember is that as soon as the marriage was over, it was not registered in England. No certification of marriage was provided by any authority in England. Various testimonial evidence that were presented during the trial in USA for the divorce case. All these trials showcased that proxy marriage was valid under Islamic law as well as Pakistani law. It is also to be noted that after the proxy marriage took place in London, both Naima as well as Ahmed went to Naiba's house in Pakistan, and there a Rukhsati ceremony, giving away of the bride, the Rukhsati ceremony was performed. Not the marriage, just the Rukhsati ceremony. After the Rukhsati ceremony was over, the couple returned back to Virginia, brought a home together, a jointly titled, and they settled down in this property as husband and wife, where they lived as a couple for more than a year, after which they decided to separate. Ahmed filed a petition for the marriage to be declared as void. He said that under English law, proxy marriages are not permitted. Whereas Naima was having an argument saying that under Islamic law, proxy marriage is valid. And as far as Pakistan is concerned, there also proxy marriage is validated. So if the marriage is void ab initio, the positioning is such that if the marriage is void ab initio, Ahmed need not pay the meher amount. There was no marriage, therefore there is no need for payment of dower. Whereas if Naima's claim is correct, the dower amount also needs to be paid. Ahmed argued no proxy marriage, no valid marriage, therefore no need for payment of the meher amount. He pointed out that under English law, if at all someone is getting married in England, the conditions are somewhat like this. 15 days of residence by either Ahmed or Naima prior to their marriage, then compulsory registration of the marriage in England, and based on that certificate only, the marriage is deemed to be a valid one. Now, Naima put forth a counter argument saying that as soon as the proxy ceremony was over, we went to Pakistan. In Pakistan, proxy marriages are valid. The marriage took place in Pakistan. Therefore, make use of Pakistani law to identify whether the marriage is valid or not. This brings out a series of points. First and foremost, the US court needs to decide whether the marriage is valid. And before determining that, it has to find out whether it is having the jurisdiction to take up the case. Since the couple had their matrimonial house in Virginia, in USA, the court said that the matrimonial residence is there in USA, therefore we have jurisdiction. Then it had to identify whether the marriage is valid. Under US laws, they have not registered their marriage in USA. No civil ceremony was conducted, no registration of marriage in USA took place. They simply purchased a house together in their name and they started their marriage life. Therefore, there is no question of validity of marriage in USA because the marriage did not take place in USA. The next question is the marriage valid in England? As Ahmed had pointed out, the marriage was not valid in England because proxy marriages are not recognized and there was no certification of the marriage. What's the position as far as Pakistan is concerned? It observed that Rukhsati ceremony that took place in Pakistan is not an essential or valid ceremony. It is not an important aspect of the marriage. And under Pakistani law, the parties had failed to cite the Nikah at the same time. Again, it is not a valid marriage because of that. Furthermore, it also pointed out that Naima belonged to a controversial sect of Muslim group which Pakistan has till date refused to recognize. Ahmadiyya sect is not recognized in Pakistan, therefore Sharia law is not applicable for them. Since the marriage was celebrated in India, it is the English law that needs to be observed. And the court said that the choice of law that the court will make to identify whether the marriage is valid or not is always the English law in this circumstance, and the English law states the marriage is not valid. And it is also observed that the marriage is not valid under USA as well as Pakistani law also. Based on all these categorization, the court held that the marriage between Ahmad and Naima never took place. Since there is no matrimonial relationship between the two, there is no question of meher amount being delivered. It said that the marriage that you are talking about is not at all there in existence. You have brought a property together. You both have to decide how to distribute the property amongst yourself. If you are unable to do so, go and file a civil case for the same. There is no question of matrimonial remedy in this scenario. So no meher amount was also granted. When you look through this case, you can see that as soon as the court identifies whether it is having jurisdiction or not, immediately the court delves into the characterization of the case. So the case is all about obtaining divorce and the meher amount. The question that arises is, before obtaining the remedy of divorce, you have to prove that the marriage is there in existence. So that is how the characterization is happening. And whether the marriage is valid or not, which law am I going to apply? Is it going to be the English law or the Pakistani law? The court was willing enough to apply both Pakistani law as well as UK's law, and it said that under either of these laws, when we look through the facts through the lens of either of these laws, there is no existence of a marriage. Therefore, there is no question of any kind of matrimonial relief. So this is how generally the court will go through the process of characterization. It might look a bit haphazard for you. Therefore, we will, in our upcoming videos, take up characterization as separate stages, three different stages, and discuss each stage one by one to give you a more coherent idea. If you found this video informative, kindly like, share, and subscribe to my channel. If you are having any doubts regarding this particular case law, raise it in the comments so that I can help you. Thank you. Have a good day.